I get this question a lot. What is probate? Well, probate is essentially an administrative process conducted through the probate court that uses the structures of the laws of the state, or the will, if you have one, to make sure there's an orderly process for the assets to be accounted for and then distributed. It basically is a series of documents that get filed with the court. There's a lot of stuff that goes on behind the scenes with that, but most people get scared when they hear of probate. They hear of a court being involved, but in most probates, there's no real involvement with the court from the family's perspective. But it is a series of steps that must be gone through appropriately, from the application with the court for to be appointed as the executor or the administrator of the estate, and then appointing that person by the court, going into filing with the court an inventory that accounts for what's in the estate, and then reporting back to the court that it's been distributed. And as long as you follow the rules, it can be a pretty smooth process. In Ohio, that process typically takes about 6 months. So there are lots of different terms that get thrown around in connection with estates and when people die that can be confusing. There are administrators, there are executors, there are trustees, and there are powers of attorney that people get confused by. Simply stated, a power of attorney is when somebody's still alive. It's giving somebody the authorization to take care of stuff for them. And that power of attorney ceases to be effective when somebody dies. At that point in time, through the administration of a probate estate, somebody's put in charge. That person is either the executor, if there is a will involved, or an administrator if there is no will involved. And their job is to take care of the administration of the estate. Now, a trustee sometimes can be involved. A trustee serves a similar role, but they serve that in connection with the administration of a trust that may have been set up. So a power of attorney, an executor, an administrator, a trustee, all perform the roles of what's called a fiduciary in connection with the administration of somebody's assets. It's just where they are in the lifetime and what the structure of the assets they're administrating or taking care of are. So the process differs if you have a will and somebody's been named as an executor, and if you don't have a will and somebody has to step forward to take care of the administration of the estate. If there's a will, like I said, there's an executor named. That person has a clear authorization to be appointed by the court to take care of the estate. Without that, then the process goes forward to have somebody appointed as an administrator of the estate. Now, that person that is appointed as administrator is technically anybody that has what's called a legal interest in the administration of the estate. That could be a family member, could be a creditor for that matter. So whoever wants to be appointed as administrator to take care of the estate has to establish to the court that they have the highest priority to take care of the estate. So for example, if a creditor did file to become an administrator of the estate, a family member would have the right to trump them, to come on top of that, and the court would appoint them instead of the creditor. But if there are multiple people in the family that all have an equal level of right to be appointed as the administrator, then they all could have their grievances heard, and the court's going to pick which one they think is the right person to serve as the administrator of the estate. So the person that the court appoints as the administrator of the estate will be required to have a fiduciary bond posted. That's an insurance policy to protect the estate against them stealing what's in the estate, adding additional costs to the administration of the estate. From that point forward, the administrator has to report back to the court what assets there are of the estate, and it proceeds very similarly to the manner in which it would proceed if you did have an executor, except if there is a house involved, where the administrator now is going to have to get specific authorization from the court to be able to sell the house, again, adding additional cost. So in a nutshell, when you have a situation where there is no will, you're going to have greater uncertainty as to who's going to take care of the administration of the estate, greater cost, and delays caused by that. And this is why most attorneys are advocates of making sure that everybody has a will, regardless of the size of the estate. It's very common to come across situations where somebody has died, a husband's died, a wife has died, and the remaining spouse didn't do anything with transferring the property. And if enough time has passed before that second person passes away, then there is a special procedure that we can go through and avoid the administration of that property to transfer it to the spouse. But other than that situation, if somebody passes away and owns real estate, hopefully they co-own it with somebody with what's called a survivorship right. And that is language that is found in the deed. It typically says from the sellers of the property to the buyers with the magic phrase, for their joint lives remainder to the survivor of them. And if that's the case and one of them passes away, all that needs to be done to transfer that property to the survivor is to file an appropriate affidavit with the county recorder that shows that that person has passed away, and that will have the effect of transferring the remaining value to the other survivor. If the property is not held jointly with rights of survivorship in that fashion, then it's most likely going to have to go through a probate process to transfer that asset to the next person, or persons, if it is going to kids, for example. And what will happen in that situation is through the administration of the estate, the executor or administrator of the estate would issue what's called a certificate of transfer, transferring that property to them, recording that in the county recorder's office, and that will have the same effect as a deed transferring that property to them, to show anybody who looks at the property records that those people are now the owners of the property. Many times people call our office wondering about the terms of the will. They think that there was a will out there. They're not sure. They're just kind of in the dark, feel like they don't have the access to the information. Well, first of all, understand that while somebody's alive, a will is a private document. Nobody has a legal right to see that document. Now, once somebody passes away, then if there is a will, then whoever is appointed as the executor in that will has a legal obligation to submit it to the court if there's going to be an estate. From that point on, if you have a right in the property of the estate, either because you're named in the will or because you are the natural heir of that person, one of the children of a deceased parent, for example, then whomever's administrating the estate does have an obligation to provide you notice of what's going on with the estate, to make sure that you are told who's asking the court to put them in charge and where that's being done at, where the court is, for example. So there are legal requirements to make sure that if you have an interest in the estate that you will be provided notice. Now, if you think that you had an interest in an old will that is gone and you're not an heir at law, then it could be a very frustrating experience. And without having a legal basis to challenge what's going on, then you may find yourself in a position where you are not allowed access to that information. And that's when you need to bring in a lawyer. Common question is, how much is this going to cost? And unfortunately, there's no set fee structure typically for the administration of a probate estate. And it's very much dependent upon the actions that have to be taken. Now, there used to be a rule of thumb that in Ohio, a probate estate would cost between 3 and 4% of the value of the probate estate. That's still a good starting point to try to wrap your head around how much it could cost. Most attorneys do charge some form of hourly rate. And the cost is very dependent upon the actions that are taken by the people involved in the estate. If the administrator or the executor is going to do a lot of the work, then the legal fees may be fairly insubstantial. But if they need a lot of intervention and assistance by the legal team, then the fees can be very substantial at times. So it all does come down to how much work needs to be done and what are the complexities involved in the estate. Most estates, again, that 3 to 4% number that has been a rule of thumb for years still holds fairly true as a high point, but there are sometimes situations where it goes much past that.